Hello everyone, welcome to the International Marketing class. Today, we're going to talk about the international legal environment of the firm. This chapter deals with two broad issues involving the legal environment. The first issue is concerned with the problems that arise with international commercial contracts and settling disputes when they arise. The second issue concerns the common law in international market basis for countries' legal system, which creates problems for multinational companies when interpreting the laws in countries whose legal systems are based either on code, socialist, or Islamic law. A review of the different legal system is important for you to appreciate the problems that arise in protecting such things as intellectual property rights and other international business law. The teaching objectives of this chapter are to know and understand the different international business law and its basis. Secondly, is the protection of intellectual property rights. And the third one is for us to be familiarized with cyber law and commercial laws. Dealing with international business is really complicated and requires wide consideration of legality and compliance with rules and regulations. Every country has a distinct rules to follow, which shows that there is no uniformity in international business law. As an international trader, it is important to understand the basic laws and how to follow these policies. There are four heritage forms as the basis for the majority of the legal systems of the world. These are common law, civil or code law, Islamic law, and commercial legal system. And there are also three basic types of legal systems. And the commercial legal systems in the Marxist economies, although not a formal system, is worth discussing. One measure of the importance of the legal system in each country is the number of attorneys per capita. If you could take a look on the 6.1 exhibit, okay, judging by that metric, the legal system is called upon to settle commercial disputes much more frequently in the United States than in almost all other countries, and particularly China. So if you take a look, China's legal system is really only 50 years old in the 1980s, and the country had 3,000 attorneys, and now the number is closer to 150,000. By comparison, the legal system in Japan is much more developed than China. Even so, as the Japanese economy continues to become more integrated in the global market, the need for attorney is not growing. Despite government encouragement to open US-style law schools, the demand for legal services in Japan remains low, now at about 37,000. Now let's move on to the discussion of four heritages form the basis for the majority of legal system. Let's start with the common law. Common law is based on historical or past practices. Therefore, under common law, all judgments in court are based on precedents. Common law seeks interpretation through the past decisions of higher courts which interpret the same statutes or apply established and customary principles of law to a similar set of facts. The second basis for legal system is the code law. It was derived from Roman law that can be found in Germany, Japan, France, non-Islamic and non-Marxist countries. So this code law is based on all-inclusive system of written rules of law. This law, the code law, has three main codes: commercial, civil, and criminal. All laws are codified, but broad interpretations are possible. Common law countries are starting to codify commercial law. Another illustration of how fundamental differences in the two systems can cause difficulty is in the performance of a contract. Under common law in the United States, the impossibility of performance does not necessarily excuse compliance with the provisions of a contract unless compliance is impossible because of an act of God, such as some extraordinary occurrences of nature not reasonably anticipated by either party of a contract. Hence, like for example, flood, lightning, earthquake, and similar events are generally considered acts of God. Under code law, acts of God are not limited solely to acts of nature, but are extended to include unavoidable interference with performance, whether resulting from forces of nature or unforeseeable human acts, including such things as labor strikes and riots. The second basis of legal system is Islamic law or Sharia. It is based on the interpretation of the Quran on how people is going to behave, specifically with the property rights, economic decision making, and economic freedom. It also considers the objective of social justice and equality. This also prohibits investment in activities that violate Sharia. One of the specific examples is the banking in Dubai, United Arab Emirates. You have to understand that they prohibit bank transactions related to alcohol and gambling payments because it is the principle of Islamic law that affect banking. The next basis of legal system is the Marxist socialist tenets. As socialist countries become more directly involved in trade with non-Marxist countries, it has been necessary to develop a commercial legal system that permits them to engage in active international commerce. For example, China has announced that it will adopt a constitution-based socialist legal system but with Chinese characteristics. Another example is China has strict cyber laws and prohibits the use and access to certain websites such as Facebook, but has formed its own social media site that the government can monitor closely, and they call it QQ. Some formerly communist Eastern European countries had a formally codified legal system before the onset of communism and are adopting that to engage in global trade. Another problem of international marketer is determining whose legal system to follow. Unfortunately, there is no judicial body exists to deal with legal commercial problems arising among citizens of different countries. How does these legal disputes can arise? It can arise in three situations: between governments, between company and government, and between two companies. This dispute can be resolved using regulations passed through conventions like the World Court at The Hague, since there was a convention held there and ratify a policy related to a sea dispute, and it can be handled also by international commercial arbitration centers. Most importantly, that this kind of a settling or resolving the dispute must be written in the contract of sales. It must be decided by both parties on what kind of arbitration or what kind of system they are going to use in resolving a dispute in the future. Because there is no international commercial law, the marketer has to look into the type of law and the specific laws of each country the firm has operations in. It is very important when operating in another country to have the supporting documents that clearly state the jurisdiction in case dispute occurs about whose law will apply. That's why, as I had mentioned a while ago, that this kind of jurisdiction or this kind of dispute resolution must be written in the contract. Either they're going to use institutional arbitration or they're going to follow a ad hoc arbitration. Okay, so you have to consider which law governs. Okay, it can be determined by your terms and condition written in your contract, where a contract was entered into, or where the provisions of the contract were performed. There are different ways to resolve international dispute, either through conciliation, arbitration, and litigation. The track record for the conciliation process is excellent, with most disputes reaching settlement and leading to the resumption of business between the disputants. Conciliation is considered especially effective in resolving disputes with the Chinese as it is non-threatening. So you can do conciliation by resolving dispute by asking third party to mediate. There will be some discussion during the mediation and is confidential. And it may not be used in future litigation or arbitration. On this kind of resolution, you are not legally binded. The second method to resolve international dispute is through arbitration. It is kind of similar with conciliation, but it is more on uh, the party are legally binded. Parties agree to rules and procedures of some arbitration tribunal. Parties agree to abide by the awards resulting from the arbitration. They are legally binding in most countries, and some of the active arbitral centers established by countries, organizations, and institutions. Example, the Inter-American Commercial Arbitration Commission, the Canadian American Commercial Arbitration Commission for disputes between Canadian and U.S. businesses. And also, we also have the London Court of Arbitration. So the decisions are enforceable under English law and English courts. And we also have the American Arbitration Association, and specifically each country has an international dispute resolution center. For arbitration, both parties going to select an arbitrator or the disinterested and informed party. He is going to determine the merits of the dispute and make judgment for both parties. Many arbitral centers in the world has its own standard procedures. Arbitration clauses require agreement on two counts, and besides arbitration agreement, the contract of sales must be implemented and honored. The third method to resolve international dispute is through litigation. Litigation is the last resort and not a preferred option in most disputes, especially in countries where it is considered public humiliation. For all of the above reasons, disputes are best resolved through conciliation or arbitration. Litigation is commonly initiated by lawsuit, and you need a lawyer to defend yourself. And the reason why they are avoiding litigation is because of fear of creating poor image and damaging public relations, fear of unfair treatment in foreign courts, difficulty in collecting judgment that may otherwise have been in a mutually agreed settlement through arbitration, and it is expensive and it requires a lot of time. And lastly, it would create the loss of confidentiality. One of the common problems in international business is the protection of intellectual property rights. Companies are really going to spend $1 million just to establish brand names or trademarks that will symbolize quality and design, and it helps to entice customers to buy their products. Millions are spent on research to development products, patented processes. designs, and formulas that provide companies with advantages over their competitors. So these intellectual or industrial properties are among the more valuable assets of company like Apple, Coca-Cola, and Gucci. They really protect their logo and their names. For example, Marlboro brand had a value of $33 billion. Kellogg's is around $9 billion. Microsoft is $9.8 billion, and Levi's for $5 billion. They all have experienced infringement of their intellectual property rights because some other company are copying their products or producing a product similar to their products, which is this company do not give a permits to those kind of a company who manufacture the same products, and we call it counterfeiting. Counterfeiting and piracy is a method of copying the products of a company wherein they were not given a permit. So it occurs in a range of industries like apparel, automotive parts, agriculture, chemicals, pharmaceuticals, books, records, films, computer software, mobile phones, baby formula, and a lot more. So it estimates that more than 10 million fake Swiss timepieces carrying famous brands such as Cartier and Rolex are sold every year, and this is illegal. Of course, if I am the firm who manufactured the original product, I might be angry and file a case against them. So counterfeiting and piracy is illegal. Some feel the intellectual property regime has gone too far in favor of firms, hinders creativity. Software, music, and movies are especially attractive targets for piracy because they are costly to develop but cheap to reproduce and distribute all over the internet. A good example is that a US software that sells for $500 in this country can be purchased for less than $10 in East Asia. In Exhibit 7.2, you can see the piracy rates for computer software. The highest rates came from the country of Libya and Zimbabwe, wherein they got 90% rating of piracy. And the lowest rates for piracy is in the United States, that got a rating of 17%, and Japan and New Zealand of 18%. This implies that a country with the highest rates of piracy shows that their intellectual property rights policy is not empowered or it's not being implemented well. And to those countries who has a lowest rate of piracy, they implement their piracy law extremely well. They really have rules and regulations about counterfeiting and piracy. If you're going to travel to United States, they have some random checking in the airport. If you are carrying a luxurious brand items, you are going to be checked randomly or occasionally, and they're going to ask you to present the certification or authentication card of the product that you are carrying, because they have a rules or they have a law that when you enter into their country using counterfeited products, you will face a penalty, or either you will be sent off to your country. That's why make sure if you're going to use Louis Vuitton, Gucci, Coach, Hermes bag, Torch, make sure that they are authentic, because we may not know that there will be some random checking and you will be caught on the spot. Why, despite of the different international property rights law, there are still this kind of counterfeiting and piracy? because there is a failure to protect intellectual property rights and it is inadequately in the world marketplace that can lead to the legal loss of rights in potentially profitable markets. One of the more frequent errors is assuming that company has established rights in different countries, so they will be protected around the world, or that the rightful ownership can be established should the need arise. Not only is there inadequate protection for trademark or brands in other countries can register and have rights to brand like McDonald's or Coach, and there is no legal protection. Some companies are refusing to pay high rates to get their trademark back from squatters, assuming they will give it up as there is no benefit to them. Particularly in United States, they have a common law wherein ownership of intellectual property right is established by prior use. So whoever can establish first use is typically considered the rightful owner. But in many code law countries, the ownership is established by a registration rather than prior use. The first to register a trademark or other property right is considered the rightful owner. I want to give you an example of a trademark infringement or case in the country of Jordan. Okay? In the Middle East, a trademark in Jordan belongs to whoever registered it first in Jordan. So you can find McDonald's restaurant, Microsoft software, and Safeway groceries all legally belonging to Jordanians. After a long court battle that went to the Spanish Supreme Court, Nike lost its right to use the Nike brand for sports apparel in Spain. That is another example in Spain. Side Sport of Spain had been using Nike for sports apparel since 1932 and sued to block Nike USA sportswear sales because Side Sport does not sell shoes under the Nike label. The Nike US will be able to continue selling its brand of sports shoes in Spain. So a company that believes it can always establish ownership in another country by proving it used the trademark or brand name first is wrong and risks the loss of these assets. The World Intellectual Property Organization, or the WIPO of the United Nations, is responsible for the promotion of the protection of intellectual property and for the administration of the various multilateral treaties through cooperation among its member states. The Patent Cooperation Treaty facilitates the patent application process among its member countries. The European Patent Convention has a regional patent system that allows any nationality to file a single international application for a European patent. The side agreements of the World Trade Organization called TRIPS, that is the trade-related aspects of intellectual property rights, is one of the most comprehensive treaties that details intellectual property rights protection in member nations. So in international conventions, they talk about the rules and regulations on the processing of providing or giving a certificates or permits or a license for the intellectual property rights. Okay, so there are three major conventions: the Paris Convention for the protection of industrial property, the Inter-American Convention, and the Madrid Agreement. So they have a convention, they have a series of meetings on how they're going to establish a policy related to intellectual property rights. What are the other managerial approaches? Number one, we have the traditional remedies, wherein it engaged local representation and diligently register intellectual property with appropriate agency, that is prevention. And they also pursue negation and alternative dispute resolution. They complain to authorities of host nation, complain to domestic government and World Trade Organization. There was a times in China wherein Jackie Chan, if you are familiar with Jackie Chan, um, he represents the International Property Rights Agency to call on with the firms in China to stop counterfeiting. Jackie Chan helps the Chinese government crack down, forecast the probable path of intellectual property rights in China. That is, pirates have turned into policemen historically in the United States, Japan, and Taiwan as the production of intellectual property took off in each country. How company protect against piracy and counterfeiting, like for Microsoft, Bill Gates, a negotiation strategy with China's software pirates demonstrate his skill, prescience, and patience. According to Bill Gates, if they steal, I want them to steal my product. Philosophy paid off when Bill Gates legally signed a deal with Lenovo in 2006 for all Lenovo computers to come with Microsoft products. For Philips, they engage in open innovation policy. And the Warner Brothers, they engage in charge what the market will bear policy. There was an instance in China wherein a potential customer visited a Microsoft booth in Beijing. When Chinese blogger used Microsoft service to post messages and type in such terms as democracy, capitalism, liberty, or human rights, they get a yellow light and a computer warning. So this message includes forbidden language because it somehow promotes like an advocacy of freedom. As you know, China is a communist country. So they receive a message about please delete the prohibited expression. Microsoft has agreed to this sort of censorship, explaining that it is just following local laws and that the company still provides a most useful service to its Chinese client. That's why last week I asked you to come up with a commercial wherein an advertisement had been used, okay, to promote or to give an information related to social issues. In the past, a company was deemed to have a taxable presence in a country if it had a permanent establishment there. But whether the existence of a server or a website qualifies as such a presence is not clear. One's proposal that has enthusiastic support from tax authorities is for servers to be designated as virtual permanent establishment and thus subject to local taxes. The European Union Commission has implemented directive to force foreign companies to levy value-added tax on services delivered via internet, television, or radio to customers in the European Union. So these are the related laws, specifically taxes, wherein they are asking people that they can work from anywhere using the internet, but the issue is how they're going to collect the tax since all of the transactions are being done through internet. So there will be the questions of honesty if they're going to declare the right amount of income that they collected through online. The European Union has adopted an e-commerce directive that will permit online retailers to trade by the rules of their home country unless the seller had enticed or approached the consumer by way of advertising. Establishing the validity of contractual law for e-commerce is making substantial progress also. In India, for example, recently they passed a law that recognizes email as a valid form of communication, electronic contracts as legal and enforceable, and digital signatures as binding. Several countries are preparing or have passed similar legislation to the United Kingdoms that allows digital signatures to be used in the creations of online contracts that are as legally binding as any paper-based original documents. But of course, not all of the country are accepting electronic signature as accepted and legally binded evidence for the contract. Still, the traditional method is that you have to sign manually the contract to make the document legally binded or acceptable in the court. When doing business in more than one country, a marketer must remain alert, okay, to the different legal system, especially troublesome for the marketer who formulates a common marketing plan to be implemented in several countries. You have to consider the different laws and follow and comply with it. Specifically, the unique laws in marketing like promotion, development, labeling, pricing, sales distribution. Each country has a particular standards of marketing law. So these laws vary in strictness by country and industry. There are some discrepancies that create challenges for marketers and traders. There is a hope of common commercial code across countries like what the European Union is attempting to standardize the law of marketing. But commonly, as an exporter or importer, you have to abide the international trading law or the commercial law within the country. In my country, the Philippines, there was a times wherein there's a documentary story about selling of organs. You can buy yourself a kidney on the black market for the global price around $2,000. But this kind of practice is prohibited in our country. They are doing this uh, behind the law or underground transaction. We strictly implement rules and regulations on buying and selling of human organs. In other country, they are legal, but in our country, in the Philippines, it is not legal. However, this kind of business transaction is being done under the table or behind the authorities. Another commercial law within countries that multinational corporations also is facing is a growing variety of legislation designed to address environmental issues, and we call it green marketing legislation. So it covers environmental protection of global concerns. It covers beyond industrial pollution, hazardous waste disposal, and rampant deforestation to include issues that focus directly on consumer products. So these green marketing laws focus on environmentally friendly products and product packaging and its effect on solid waste management. That's why there is an emergence of green business, green practices, green hotel, green restaurants, and we call it also like green industry. Germany has most stringent laws. They regulate management and recycling of packaging waste. I think they are the number one in the world, and Korea is on the top three. Eco-label in Europe for products that comply with criteria. Another commercial law within country is the foreign countries antitrust law. The China, European Union, Japan, and India in many countries have been actively enforce this kind of antitrust law, and they pattern it to the United States. So this law governs the anti-monopoly, price discrimination, supplies restrictions, and full line forcing are areas in which the European Court of Justice has dealt severe penalties. For example, before, Procter and Gamble was allowed to buy BP Schizodos AG, that is a German hygiene products company. It had to agree to sell off one of the German company's decisions or divisions that produced Camellia, a brand of sanitary napkins. Because Procter and Gamble already marketed a brand of sanitary napkins in Europe, the Commission was concerned that allowing Procter and Gamble to keep Camellia would give a company controlling 60% of the German sanitary products market and 81% of Spain. So more recently, the European Union fined Intel the $1.45 billion of monopolistic abuses in its marketing in Europe. So those are some of the examples of the commercial law within countries, specifically for foreign countries antitrust. Of course, all governments are concerned with protecting their political and economic interests domestically and internationally. Any activity or action, wherever it occurs that adversely threatens national interest, is subject to government control, and it is covered with their home country laws. Specifically, we have the Foreign Corrupt Practices Act, or the FCPA of United States. Illegal for companies to pay bribes to foreign officials, candidates, or political parties. Here in Korea, your policies around like a, a firm could only give a gift, okay, not more than 50,000 won. That's my understanding with your law. Beyond 50,000 won is already a bribery. And U.S. antitrust law can be applied in foreign markets. Although United States firms seem able to compete and survive without resorting to bribery in the most corrupt societies, it does not mean that violations do not occur or that companies are not penalized for violations. For example, a United States environmental engineering firm was found to have made corrupt payments to an Egyptian government official to assist the company in gaining a contract. The company agreed not to violate the FCPA in the future, to pay a civil fine of $400,000 and to reimburse the Department of Justice for the cost of the investigation. And here are also some of the specific example of commercial law within countries. Anti-boycott law, extraterritoriality of U.S. laws, policy on exports and import, and national security laws. Every country has a counterpart kind of law related to this U.S. commercial law within country. Anti-boycott law, this forbidden the company to participate in any unauthorized foreign boycotts. Furthermore, they are required to report or any request to cooperate a boycott. The Arab League boycott of Israel has three levels. Primary boycott bans direct trade between Arab states and Israel. A secondary boycott bars Arab governments from doing business with companies that do business with Israel, and a tertiary boycott bans Arab governments from doing business with companies to do business with companies doing business with Israel. So this is a long a dispute between Saudi Arabia and Israel. Okay, and for extraterritoriality of U.S. law, okay, so it causes anxiety for foreign heads of states. U.S. law can interfere with economic or political goals. Multinational corporations are held liable for activities that violate human rights, like doing business with oppressive regimes, lawsuits brought to U.S. courts by foreign countries. And also for the policy and export and imports, These are the rules that govern on how you're going to export your products and import your products, including the custom administration policy. And the last one is the national security law. Anything that will threaten the national security uh, is violating this kind of law, like selling and production of a weapon, okay, that is prohibited under this national security law. Currently, the United States had banned a government that banned the government of Iran and in trading. It restricts trade with Iran and the sale of leading edge electronics, and it prohibits the export of pesticides that have not been approved for the use in the United States. So this is to avoid the return of residue of unauthorized pesticides in imported food and protect U.S. consumers from the so-called circle of poison. So this kind of international business law will help marketer or the business itself to be protected and develop successful marketing program. This policy is not to peer but to complement with the resources and for the benefits of the operations of the business in international market. It is very important that political climate, cultural differences, local geography, different business customs, and the stage of economic development must be taken account so that it will protect and it will help the firm to position their products, their services in international market, following and complying the legal matters. Remember, the major or the primary marketing task is to develop a plan that will be enhanced or at least not adversely affected by these and other environmental elements. The important concept of this international business law is, is to create a prudent path to follow at all stages of foreign marketing operations, and that is one leading to competent counsel, well reversed in the intricacies of the international legal government. So I hope that you understand very well the importance of different international business laws, the different kinds of international business laws, and how it will affect your uh, firm positioning your marketing strategy. And if you have any further questions, just send me a message and I will be much willing to answer all of your queries. So this is your professor, Dr. Christine Joy Simpao. Have a nice day, everyone. Thank you.